Christy, I'm going to hijack the segment for just a second to talk about Rust, because I really want people to understand why that case got dismissed the way it did right when they were in the midst of a jury trial.
Right. So about a few months ago in March, a witness comes into the sheriff's office and says, we have live ammunition that's related to this Rust shooting that Alec Baldwin is now on trial for. And what did the prosecutor do? I mean, what they should have done was immediately turn that over to the defense, let them know that this witness existed, let them know about this ammunition so they can inspect it. Instead, they buried it in a case file on a different number and never told the defense about it. It's critical evidence. It's evidence that could have been, and apparently was after inspection by the judge, favorable to the defense. And so the fact that the prosecutors did not disclose that evidence until the middle of the trial when this came out was enough for the judge to say, this was in bad faith. There's no way for the court to correct this prejudice. And so I'm dismissing the case with prejudice, which means they can't go back and charge him again.
And it was especially because the jury had already been sworn, and so double jeopardy had attached, correct?
Yes, correct.
All righty. Okay, so now we're going to go to the immunity thing. Hugo, you had exclusive reporting in The Guardian about the plan for Trump Legal to weaponize the immunity ruling from SCOTUS, to be able to use it to make sure that Americans don't hear the evidence that otherwise would be presented in a jury trial, but they don't hear it before November. What's kind of the grand scheme that's going on there?
Well, the grand scheme is that the evidence that could come out of an evidentiary hearing where they go through a fact-finding analysis with potential live witnesses on the stand could be politically very damaging. I mean, it will be reported. It will be reported in the way that the January 6th committee hearings were reported. And I think there is a sense inside, Trump's legal team that they want to foreclose this at the outset. And so they will do everything they can, first of all, to not have any hearings at all. And they will argue to Judge Chutkan that this can be resolved on kind of legal arguments and their briefs, and they don't need witnesses to say this was candidate Trump acting versus President Trump acting. And if Judge Chutkan does order hearings with witnesses, they have a plan for that as well, which is to say, well, anyone that was close to Trump in the White House, we're going to assert executive privilege. We know it's already been litigated before, but we're going to relitigate it anyway. And then as for people like John Eastman and these people on the fringes who weren't part of the federal government, they'll say, well, some of these guys have been charged in Fulton County and other jurisdictions. Fifth Amendment concerns, can't have them testify at all. And they just want to shut down any notion of these guys testifying about Trump's conduct around January 6th.
But Christy, didn't they do that when they presented their briefs to the Supreme Court, and the Supreme Court said, through the majority opinion, you need to have a hearing so Chutkan can decide what's really official or not?
Throughout this opinion, the Supreme Court really was lambasting, I think, the lower court for not doing more fact-finding.
Exactly.
Like, there were various points where saying, like, look, you guys sped this up, you didn't develop the factual record, and we need more facts. Multiple times, you need fact-specific analysis. They say it over and over again. So this idea that we're just going to submit briefs and that'll be the end of it, no, Judge Chutkan has her marching orders. She has to hold hearings. She has to get to the facts. That is what the Supreme Court directed her to do, and I expect she's going to roll up her sleeves and do it quickly. She will have some briefing in advance. And yes, I imagine there'll be some fights of who is available. But again, as Hugo said, a lot of this has been litigated before. Issues of executive privilege have been litigated. I expect those hearings will happen before the election.
And I will say executive privilege is not new territory. It is established law, although the Supreme Court does stuff a little bit differently these days when it comes to precedent. But it is established law, which kind of dovetails to, Hugo, something you and I are always covering all these Trump things together. We're in the Mar-a-Lago case. We were just in Fort Pierce a couple of weeks ago. As predicted, we saw the immunity decision being deployed by Trump Legal to say, guess what? We need to be able to have some briefing on this. Jack Smith yesterday filing a response to Trump's notice of supplemental authority, the authority being this Clarence Thomas concurrence talking about the appointment of special counsel Jack Smith and relying upon that concurrence. But Jack Smith saying, no, you should disregard it. I mean, what are your thoughts about this filing?
The line from the special counsel in this filing was particularly biting, and it was, just because a single justice has opined on something that wasn't briefed and wasn't at issue in the January 6th case is not binding on you, Judge Cannon. And that was what they set forth in their filing. And I think that's probably the smartest way to go about it, because Trump's lawyers have fixated on that Clarence Thomas line as a sort of off-ramp for Judge Cannon. And they want Judge Cannon now to be able to say, well, if Clarence Thomas, who's the Supreme Court Justice for the 11th Circuit, which is her circuit, saying, maybe there are questions over the appointment of the special counsel, then that would give her an out to do so. And I think for the special counsel to focus on that line was probably the smartest way that they could have proceeded.
Yeah, and Christy, what they also say, Jack Smith says, single justice concurrence addressing an issue that Trump did not raise, that the parties did not brief, and that was not relevant to the question presented to or decided by the court, neither binds this court nor provides a basis to deviate. But this is Aileen Cannon. This is Clarence Thomas. We all saw that concurrence, scratched our head, but said, here we go. This is totally what Cannon was waiting for.
I think it was. But just taking a step back, this is so unusual. You don't typically find a Supreme Court justice where there is not an issue squarely before them. It hasn't been briefed by the parties. It's not raised by either party. Writing a concurring opinion on something that, nobody's even argued or raised. So that is highly unusual. And it does seem like he was doing it for a purpose. He knows this issue is live before Judge Cannon. And it seems clear to me that he wanted her to look at it and see what he had to say about it. And cut and paste.
Yeah. But Hugo, there's another issue, though. Do you think then Cannon is going to order evidentiary hearings to occur based upon the immunity decision? This idea of, is there something official about the hoarding, stealing, and keeping, and the refusal to turn back over classified documents?
That's a really interesting thought, I think, because if there is one judge who is dead set on holding hearings.
By the way.
She loves hearings.
Yeah.
And she loves having non-parties brief. We had amicus briefs in a recent hearing. And even she, I think, after a while was regretting allowing so many people to kind of testify before her. But if there is one judge who I think will be so amenable to evidentiary hearings, it is Judge Cannon, ironically. And if that is the undoing of the case, because all these FBI agents testify and say, this is not official conduct for a president after his term to abscond with classified documents, and that gets reported, that would be the greatest irony in all of these cases.
She is hearing happy. She is a hearing happy judge. I do think the off-ramp, though, for her is granting the motion to dismiss on the special counsel appointment and letting that one wind its way to good. It's Christy Greenberg, Hugo Lowell. Thank you guys for being here on set. It's good to see you both.
Hey there, MSNBC fans. I'm Luke Russert, and be sure to join me, Rachel Maddow, Jen Psaki, Lawrence O'Donnell, Steve Kornacki, Joy Reid, and many more September 7th in Brooklyn, MSNBC Live Democracy 2024. Click on the link for ticket information. We will see you there.